The air in the clubhouse felt heavy that night. Folding chairs creaked as neighbors leaned forward, papers in hand, waiting for answers. It was December 19th, a winter evening in DeKalb County, Georgia, and tensions had been building for months. At the front of the room, the HOA board sat behind a long plastic table, flanked by their attorney, a tall man in a gray suit. His tie knotted too tight, his expression controlled but impatient. Residents had been demanding clarity on their rights under Georgia Statute 443223, a law designed to protect condominium owners from arbitrary board overreach. One homeowner raised her voice. "Doesn't the law say you have to give us notice before changing the bylaws? Doesn't it apply here?" The attorney leaned forward, tapping his stack of papers with a pen. His reply was curt, almost dismissive. "That statute does not apply to your community. It's irrelevant here." The room erupted with murmurs. Some residents whispered in disbelief, others shook their heads, flipping through printed copies of the law they had brought with them. They weren't lawyers, but the plain language seemed clear enough. Yet here was an HOA attorney hired with their own dues money, telling them flatly that the law didn't matter. For the residents, it was a moment of both shock and awakening. That single statement, "It does not apply," became the spark that ignited a much larger battle. The weight of a lie, what makes this moment so critical, isn't just the arrogance of the dismissal. It's what it represents, a coordinated attempt to strip homeowners of their rights by pretending the law doesn't exist. Georgia's Property Owners Association Act, POAA, and related condominium statutes exist precisely to keep HOA boards in check. They're not optional. They're the framework that ensures residents can't be steamrolled by a small group of directors or their paid counsel. But by saying the statute didn't apply, the HOA attorney wasn't just giving a legal opinion, he was shaping reality. For many homeowners in that room, he was the authority figure. If they didn't know better, they might have simply accepted his word as truth. And that's how abuse festers in HOAs across America, not always through physical acts, but through the manipulation of information. Why this law matters. Let's pause here, documentary style, to explain exactly what was at stake. Georgia Statute 443223 governs the powers and duties of condominium associations. Among other things, it ensures that boards must follow due process when altering governing documents. Homeowners have the right to be informed and participate in major decisions. Boards cannot bypass transparency or use vague interpretations to consolidate power. It's a safeguard, one of the few tools residents have to prevent their community from being hijacked by unchecked authority. So, when an HOA attorney stood before a room of homeowners and declared, "It doesn't apply to you," he wasn't just wrong. He was effectively telling residents, "You don't have those protections. You are at our mercy." A pattern of control. For the homeowners, the night crystallized something they had long suspected. Their board, along with its legal counsel, was operating less like a nonprofit organization and more like a regime determined to keep control at any cost. The pattern was familiar: information withheld from residents unless demanded, financial records delayed or denied outright, threatening letters sent over minor issues, citing bylaws selectively. Legal fees racked up, always billed to the community, never the board itself. Now, by manipulating the law itself, the board and its attorney crossed into a new territory: deliberate misinformation. One resident later recalled, "It felt like gaslighting on a massive scale. We knew what we had read, but he stood there, suit and tie, telling us we were wrong." It was designed to intimidate. The homeowner's turning point. For most in the room, frustration bubbled without a clear path forward. After all, who wants to take on a board with deep pockets and an attorney on retainer? But for one homeowner, this was a turning point. He went home that night and spread the statute across his kitchen table. Line by line, he read it again, not as a lawyer, but as a citizen trying to understand his rights. The more he read, the clearer it became. The attorney's statement was false. That realization planted the seed of determination. If the board and its lawyer were willing to deny the very existence of the law, what else were they hiding? The homeowner began documenting everything: meeting notes, emails, inconsistencies. copies of the statute with highlighted sections. He wasn't just angry. He was preparing for battle. From local conflict to national problem, what unfolded in that small Georgia community is not unique. Across the United States, HOAs and their attorneys use the same tactic: deny, dismiss, deflect. In Florida, homeowners have faced boards that misquoted statutes to justify illegal fines. In Texas, attorneys have argued that state property codes don't apply to their associations, hoping no resident would challenge it. In California, lawyers have repeatedly twisted Davis-Sterling Act provisions, telling homeowners they had fewer rights than they actually do. In every case, the result is the same: ordinary families intimidated into silence, boards emboldened to act without accountability, and homeowners footing the legal bill for their own oppression. Building the documentary tone. To the viewer, this story isn't just about one meeting or one false statement. It's about how the abuse of authority begins with words. The December 19th meeting becomes a microcosm of a larger national crisis: the erosion of homeowner rights under the guise of community management. And for this video, we'll use that meeting as our anchor scene. A tense, visual moment where the attorney's denial echoes, the camera pans across confused and angry faces, and the audience feels the injustice firsthand. From there, the narrative expands into the broader consequences: how misinformation leads to financial exploitation, how unchecked boards become authoritarian, how homeowners, once awake to the lies, start pushing back. Setting the stakes. By the end of the introduction, viewers should feel what the homeowners felt: the sting of being lied to, the frustration of being dismissed, the dawning realization that this isn't just incompetence, it's strategy. And most importantly, they should feel the urgency of the homeowner's decision to fight back. Because once one person stands up and says, "No, the law is clear, and you're lying to us," the entire balance of power begins to shift. That's where our story begins, with one night in December, one falsehood spoken with authority, and one homeowner who refused to let it stand. The December 19th board meeting was supposed to be routine. Residents had gathered in the stuffy community clubhouse, a place where plastic chairs squeaked against linoleum and the coffee urn in the back hissed like it was trying to drown out the arguments. What began as whispers of discontent soon turned into a confrontation that would change everything. The board attorney sat at the head table, papers neatly stacked, voice calm but calculated. "Florida statute 718 does not apply here," he said with authority, his tone slicing through the murmur of the crowd. "This is a private association. The rights you're referencing are simply not relevant." For a moment, silence hung over the room. Some residents looked around, confused. Others lowered their heads as though a courtroom verdict had just been handed down. But one homeowner, let's call him Daniel, didn't flinch. He had spent nights poring over Florida law, highlighter in hand, tabs sticking out of binders like battle flags. And he knew, beyond doubt, that the attorney's statement was false. Still, the damage was done, the room shifted. The board seized the moment, pressing forward with its agenda. With the supposed confirmation from their lawyer, they pushed through measures that stripped residents of key rights, limiting access to financial records, cutting off avenues for appeals, and tightening rules on property use. The denial of the statute's authority became their sword and shield. Narrator's voice, setting the stakes. It may sound technical, just a debate about whether a statute applied, but the consequences were massive. Florida Statute 718 was written to protect condominium owners from unchecked power. It guaranteed transparency, required boards to keep accurate records, and gave owners the right to challenge misconduct. By declaring the statute irrelevant, the HOA effectively told residents, "We are above the law." And that's when the conflict shifted from frustration to open resistance. The first sparks, Daniel wasn't alone. That night, after the meeting adjourned, several neighbors gathered outside in the cool December air. Their breaths fogged as they whispered like conspirators. "Did you hear that?" One woman asked, voice shaking. "They just said the law doesn't matter." "It's a lie," Daniel replied firmly. "I've read the statute myself. I've got copies. They're counting on you not to check." Another neighbor, an older man who'd lived in the community for over 2 decades, shook his head. They've been doing this for years, sliding things past us, claiming authority they don't have. But this is too far. The group agreed they would start organizing, quietly at first, then louder. Retaliation begins. The board, however, had anticipated resistance. Within days, violation notices began showing up in mailboxes. Daniel's lawn was suddenly out of compliance for a patch of grass that had gone dormant in winter. A mother down the street received a letter claiming her children's bikes were unsightly when left by the porch. Each notice carried the weight of a fine. Each fine carried the implication of a lien, and each lien threatened foreclosure. The message was clear: challenge the board and you will pay. Daniel kept a binder, this one read, marked retaliation in black marker. He logged every violation notice, every date, every photograph. He knew that if they were going to fight this battle, evidence would be their only weapon. Narrator's voice: fear as a tactic. This is the playbook of HOA overreach. By weaponizing fines and violations, boards transform ordinary rules into instruments of control. A patch of grass becomes not just landscaping, but leverage. A child's bicycle becomes not just clutter, but cause for financial penalty. When homeowners live under constant threat of punishment, speaking out becomes risky, and that fear is often enough to silence an entire community. But in this neighborhood, silence didn't hold. Cracks in the wall in January, just weeks after the meeting. Daniel requested official copies of the association's bylaws and financial statements. He was ignored. He followed up, citing his statutory right to review records. This time, he received a letter back from the board attorney. As we have explained, Statute 718 does not govern this association. Your request is denied? Daniel brought the letter to his neighbors. They gathered in living rooms and kitchens, passing the paper around like it was contraband. The denial wasn't just wrong, it was arrogant. They really think we're fools, said one resident, slamming his fist on the table. They're hiding something. Why else would they fight so hard to keep us from looking? The suspicion was contagious. More residents began asking questions. What was in the financials? Where was the money going? Why did dues keep rising while maintenance declined? The board's stonewalling only fueled the fire. Escalation by February, the conflict had become a cold war between the board and the residents. The board launched newsletters painting the dissenters as troublemakers and disruptive elements. At one meeting, the HOA president even sneered, "If you don't like it here, maybe this isn't the right community for you." But Daniel and his group weren't leaving. They were digging in. A retired paralegal in the neighborhood began researching case law, finding examples where courts had forced associations to comply with statutes they claimed didn't apply. Another resident, a tech-savvy college student, built a private email list to keep communication flowing outside the board's control. They called themselves, half-jokingly, the Resistance. And then came the first major breakthrough: the smoking gun. One night in March, Daniel received a packet slipped under his door. No return address, no explanation. Inside were photocopies of large checks made out to a contractor who, according to several neighbors, had ties to a board member's family. The amounts were staggering: $15,000, $22,000, $10,500, all marked as repairs and renovations. But when residents looked around, they couldn't find evidence of this work. Roofs still leaked, gutters sagged, sidewalks cracked. The implication was clear: money was being funneled somewhere else. Daniel held up the copies at the next clandestine meeting. "This is why they don't want us to see the financials," he said, voice low but charged. "This is fraud. And if we can prove it, they're finished." The room buzzed with anger. For the first time, people began to believe not just that the board was abusing power, but that it might actually be criminal. Narrator's voice: from conflict to crisis, this was no longer just about whether a statute applied. It was about the survival of the community itself. When boards abuse their authority, the line between mismanagement and corruption blurs. And when money is involved, the stakes climb even higher. The battle had shifted into dangerous territory. Spring arrived, but the neighborhood felt colder than ever. What should have been poolside barbecues and block parties was instead replaced by tense stares, whispered conversations, and the constant fear of retaliation. The AOA board had tightened its grip, but the residents had grown bolder. At the heart of it all was Daniel. He wasn't an elected leader. He wasn't wealthy or connected. He was just a man who refused to be lied to, and that refusal had inspired others. The first public challenge, the April board meeting, drew a crowd unlike anything the community had ever seen. Normally, a dozen people showed up at best. This time, nearly 50 residents packed into the clubhouse, shoulders brushing, the air thick with anticipation. Daniel had prepared carefully. He carried a folder, bulging with documents, copies of the checks, statutory references, and case law printouts. He had rehearsed his words, knowing full well that once he spoke, there would be no turning back. When the meeting opened for homeowner comments, Daniel stood. His voice was steady but sharp. With respect, the attorney's statement from December was false, he began. Florida statute 718 does apply here. I have the legal references in writing. And further, I have copies of financial documents showing thousands of dollars spent with no evidence of work performed. We demand answers. Gasps rippled through the room. A few residents clapped quietly. Others looked down, afraid of the fallout. The board president's face tightened. He leaned forward, microphone squealing as he snapped, "Your comments are out of order. Sit down or you will be removed." But Daniel didn't sit. He lifted the photocopied checks into the air. "This is our money? Our dues? We deserve to know where it went." The room erupted, some shouting in agreement, others trying to restore order. The president banged the gavel, the attorney whispered furiously in his ear, and for a moment it seemed the meeting might descend into chaos. Finally, the president called a recess. The board members huddled at the front table, whispering like cornered players drawing up a last-minute play. When they returned, their decision was clear. The meeting was adjourned. No answers. No discussion. Just silence. But the damage was done. For the first time, the corruption had been spoken aloud in public. And once the words were out, they couldn't be taken back. Retaliation escalates. Days later, the retaliation intensified. Daniel received a certified letter threatening legal action for defamation of the board. Another homeowner was fined $250 for leaving her trash bins visible for more than 20 minutes. A young family suddenly faced a lien notice over a $50 late fee they swore had been paid. It was clear, the board was making examples of anyone aligned with the resistance. Residents were shaken, but Daniel reminded them, this is exactly why the statute exists. This is exactly what they don't want exposed. If we back down now, they win forever. The group doubled down, building a case. The retired paralegal drafted a formal complaint to the Florida Department of Business and Professional Regulation, DBPR. It cited statute after statute, attaching copies of every denial letter, every fine, every photocopied check. The tech-savvy student began cataloging everything online, building a digital archive accessible to any resident who wanted the truth. They even reached out to local media, though at first, reporters seemed hesitant to wade into what they dismissed as a neighborhood squabble. But slowly, momentum built. Cracks in the board by June, whispers began circulating that not every board member was comfortable with the cover-up. One, a soft-spoken treasurer who rarely spoke at meetings, quietly resigned. He offered no public explanation, but his absence was noticed. The attorney's presence at meetings grew more frequent, his tone more combative. Residents couldn't help but wonder, why did a simple HOA need a lawyer at every gathering unless they had something to hide? And then came the biggest shift yet. Daniel filed an injunction. The courtroom battle. It was July when the case hit the county courthouse. On paper, it was about records access. Daniel demanding the right to review the association's books. But in reality, it was about something bigger, whether the board could continue pretending that Florida law didn't apply to them. The courtroom was small, almost intimate. Residents filled the benches, their presence turning the hearing into a quiet show of solidarity. The HOAS attorney repeated the same line he had used back in December. Florida statute 718 does not govern this association. But this time, he wasn't speaking to a room of confused homeowners. He was speaking to a judge. The judge leaned back in his chair, brow furrowed. "Counsel," he said slowly, "that is a rather extraordinary claim. Do you have supporting case law? The attorney stammered. He cited nothing. Daniel's paralegal ally, sitting beside him at counsel's table, slid forward a thick binder. Your Honor, we have multiple cases confirming that Statute 718 does apply. Furthermore, the association has actively denied statutory rights, fined residents without due process, and withheld financial records. For the first time, the power dynamic shifted. The board's shield, its attorney's confident assertion, was cracking under judicial scrutiny. Narrator's voice. The turning point, this was the moment everything changed. For months, the board had ruled through intimidation and misdirection, but in court, bravado wasn't enough. Law demanded evidence, and the evidence was on the side of the residents. The battle wasn't over far from it, but the tide had turned. Back in the neighborhood, word spread quickly after the hearing. Neighbors who had stayed silent began to speak up. I thought it was hopeless, one admitted, but maybe we can win this? The resistance had gone from a handful of whispers to a community-wide chorus. The board, sensing the shift, doubled down once more. They scheduled a special assessment vote claiming urgent repairs were needed. The sum? Over $1,000 per household. But residents weren't buying it anymore. They demanded proof of the supposed repairs. They demanded transparency. And when none came, they began organizing for something bigger, a recall. Narrator's voice. From conflict to consequence, what began as a lie in a December meeting had grown into a full-scale revolt. The board's denial of the statute had sparked not just anger, but action. Retaliation had failed to silence dissent. Evidence of financial misconduct had galvanized the community. And now, the question wasn't if the board would be challenged. It was how soon they would fall. The battle lines were drawn. The residents of that Florida community believed for a long time that their nightmare was unique. That the denial of basic rights, the stonewalling, the retaliation, it was something bizarre that had happened only to them. But the deeper they dug, the clearer it became. What they were experiencing was part of a much larger pattern. Across the United States, from sprawling subdivisions in Texas to high-rise condominiums in California, homeowners associations had become small kingdoms ruled not by democratic accountability, but by fear, misinformation, and unchecked power. A system built for abuse, the modern HOA system was originally sold to Americans as a way to protect property values. In the post-war boom of the 1960s and 70s, developers pitched HOAs as efficient, self-governing mini-governments that could handle neighborhood upkeep without burdening city halls. But what began as a maintenance model, cutting grass, maintaining pools, repairing roads, mutated into something far more controlling. HOAs were handed quasi-governmental powers, the right to fine, to lien, to foreclose. In many cases, boards of just 5 or 7 volunteers could exercise power greater than an elected mayor without the same checks and balances. The result? A system ripe for abuse. Florida, not an exception Florida, where Daniel and his neighbors were fighting, has some of the strongest statutory protections in the country. On paper, residents are entitled to financial transparency, due process before fines, and access to records. And yet, as investigative journalists have documented, boards routinely deny these rights. A 2022 Miami Herald series revealed dozens of cases where condo associations illegally blocked access to records, manipulated elections, or funneled contracts to cronies. One Miami-Dade condo treasurer was discovered to have written nearly $200,000 in checks to a vendor that turned out to be his cousin S-Shell company. When homeowners demanded an audit, the board's attorney claimed, just as in Daniel's case, that the law didn't apply. Sound familiar? The California war over privacy across the country in California, the battle looks different but follows the same script. Take the case of Jenna Kim. A homeowner fined $500 per day for something almost unthinkable, installing a small interior doorway inside her own home without prior HOA approval. When she pushed back, the HO escalated with liens and threats of foreclosure. Her story gained attention in Sacramento, where lawmakers admitted the system had spiraled out of control. Eventually, the legislature capped daily HOA fines at $100, but for Kim, The damage was done, tens of thousands in penalties and years of stress, all over a doorway that harmed no one. The pattern was clear. Rules meant for community harmony were being twisted into weapons of control. Texas. The foreclosure machine of Florida and California illustrate transparency and privacy abuse. Texas exposes the most brutal weapon HOAs wield: foreclosure. Texas law allows HOAs to foreclose on homes for unpaid dues, even amounts as small as a few $100s. In Houston alone, more than 5,000 homes were foreclosed by HOAs between 2010 and 2020. One retired veteran lost his home over $800 in unpaid assessments. He begged the board for a payment plan. Here, too, the structure encourages abuse. Boards benefit when homes are foreclosed cheaply and resold, often to investors with inside connections. Georgia. When HOAs play utility company in DeKalb County, Georgia, the Waldrop Place condominiums made national headlines in 2023. The HOA, they're struggling with debt and mismanagement cut off residents' water supply. That's right. An HOA board, not a government, decided when and if hundreds of families could have running water. It later emerged that the board didn't even have the legal authority to shut off water. But by the time the county intervened, residents had already endured weeks of living in conditions closer to the 19th century than modern suburbia. The story underscored a chilling truth. HOAs wield powers they were never designed to hold, and when abused, those powers can endanger health, safety, and dignity itself. Patterns emerging whether in Florida, California, Texas, or Georgia, the common threads are unmistakable. Denial of rights. Boards claim laws don't apply, or they obscure records to cover up misconduct. Retaliation. Homeowners who question authority are hit with fines, liens, or even lawsuits. Financial secrecy. Contracts, kickbacks, and sweetheart deals thrive in the shadows. Weaponized rules. Trivial violations become excuses for harassment or foreclosure. In short, what Daniel and his neighbors faced wasn't an isolated skirmish. It was part of a systemic war between ordinary homeowners and the unchecked private governments ruling their communities. The psychological toll experts often note the financial cost of HOA abuse, but just as devastating is the psychological burden. In surveys by advocacy groups like the Coalition for Community Housing Transparency, more than 60% of homeowners in disputes reported symptoms of anxiety, insomnia, or depression. For many, their home, supposed to be their sanctuary, becomes a battlefield. One Nevada woman compared it to living under occupation. Every day she wondered if another letter, fine, or threat would appear in her mailbox. Daniel's neighbors felt the same. The board's actions weren't just about money. They were about control, about breaking the will of anyone who dared to resist. Narrator's voice, a national reckoning. By the mid-2020s, the cracks in the system were too large to ignore. State legislatures began debating reforms. Journalists began treating HOA scandals not as quirky neighborhood disputes, but as serious governance failures. But reform was slow. For every law passed in California or Florida, dozens of boards across the country continued to operate in the shadows, confident that homeowners wouldn't know their rights or would be too afraid to fight back. This was the wider battlefield Daniel had unknowingly stepped into. His fight wasn't just about one Florida neighborhood. It was about a national struggle and American reckoning with the unchecked power of HOAs. Closing beat of this section, the December lie that sparked his Community-S uprising was just one page in a story being written across the country. From Miami to Sacramento, from Houston to Atlanta, millions of homeowners were discovering the same truth, that behind the manicured lawns and freshly painted fences, HOAs had become something darker, an empire of unaccountable power, exploiting the very people it was supposed to serve. And Daniel, like so many others, was about to find out just how high the stakes could go. By now, Daniel and his neighbors knew they weren't just facing stubborn board members. They were confronting a system that blurred the lines between private contract law and public governance. And that raised one of the most important questions of their fight. When does a homeowners association cross from enforcing rules into violating rights? The legal foundation of HOAs. At its core, every HOA rests on a set of documents, the Declaration of Covenants, Conditions, and Restrictions, CC and RS. These are binding contracts. By purchasing property, homeowners agree to follow the rules written decades earlier by developers' rules that are often vague, outdated, or riddled with loopholes. Legally, courts treat CC and RS like contracts. Boards are empowered to enforce them, and homeowners are obligated to comply. But here's where it gets complicated. Unlike a contract between two equal parties, the HOA has the upper hand. It holds the power to fine, to lien, and in some states even to foreclose. This imbalance is why many legal scholars call HOAs private governments entities that can tax, police, and punish, often without the safeguards built into actual government. Due process in question: consider due process. Under the U.S. Constitution, no government can deprive you of property without notice and an opportunity to be heard. But HOAs, as private entities, aren't bound by constitutional protections in the same way. States attempt to fill this gap. Florida law, for instance, requires HOAs to provide written notice before levying fines and to allow for a hearing before an independent committee. On paper, that sounds fair, but in practice, boards manipulate the process. Independent committees are often handpicked allies of the board. Hearings are conducted in living rooms, not courtrooms. And when boards refuse to comply, homeowners are told their only recourse is to file a lawsuit, an expensive, exhausting endeavor. The result is a shadow justice system where procedural safeguards exist more in theory than in reality. Fiduciary duty and its breach. HOA board members are supposed to act with fiduciary duty, a legal obligation to act in the best interests of the community. It's the same standard that governs trustees or corporate directors, yet time and again boards violate this duty. By stonewalling financial records, misusing funds, or retaliating against critics, they betray the very homeowners they serve. In Daniel's case, the refusal to release financial records was more than arrogance. It was a direct violation of state law, which requires transparency. Courts have ruled that denying access to records constitutes a breach of fiduciary duty. And yet enforcement is weak. Boards often gamble that no one will sue or that their attorneys, paid with HOA funds, will outlast the homeowner's resources. The weaponization of fines. Legally, fines are meant to ensure compliance, not to generate revenue. But in practice, fines become a weapon. In California, fines for trivial violations like leaving trash bins out too long can snowball into thousands of dollars. In Texas, unpaid fines can lead to foreclosure. In Florida, homeowners like Daniel face escalating penalties designed not to encourage compliance, but to silence dissent. The ethical issue is clear. When enforcement crosses from maintaining harmony to exerting control, it ceases to be governance and becomes coercion. The right to property versus the right to rule. At the heart of every HOA dispute lies a fundamental tension: who truly owns the home? Homeowners believe that by purchasing property, they hold the ultimate right to decide how it is used, decorated, or modified within reason. But HOAs claim authority to dictate nearly every detail: the color of the front door, the height of the grass, even interior modifications in some cases. This raises profound ethical questions. Does a board's power to protect property values justify invading privacy or restricting autonomy? When a board fines or forecloses, is it preserving the community or violating the very idea of private property? For many critics, HOAs reveal the paradox of American homeownership. You may own your house, but you don't fully control it. The role of attorneys. Another legal wrinkle is the role of HOA attorneys. In theory, association lawyers represent the HOA as a whole, that is, the collective interests of all homeowners. But in practice, they often serve the board, shielding it from accountability. Letters drafted by these attorneys are filled with legal threats, designed to intimidate rather than resolve. Homeowners pay for these attorneys through their dues even when the attorneys are used against them. Ethically, this is one of the most troubling dynamics: neighbors funding their own oppression. When HOAs act like governments, the ethical stakes rise even higher when we consider the functions HOAs sometimes take on. In Georgia, as we saw, an HOA acted like a utility company by cutting off water. In Nevada, some HOAs have run private security patrols, blurring the line between neighborhood watch and unregulated policing. In Arizona, HOAs have been accused of voter suppression in board elections, denying ballots to critics or manipulating proxies. Yet, unlike cities or counties, these mini-governments are not subject to constitutional checks. No First Amendment right to free speech at a board meeting. No Fourth Amendment right against unreasonable searches when a board demands entry. This creates what legal scholars call a democracy gap. Millions of Americans live under a government they never voted for and cannot easily reform. The ethical lens, power and accountability ethically, the core problem is accountability. True democracy requires transparency, oversight, and the ability to challenge authority. But in HOA land, those principles are often inverted. Transparency is denied, oversight is weak. Challenges are punished. The ethical implications extend beyond homeowners to society at large. When private governments erode trust, silence dissent, and strip rights, they don't just harm individual residents. They corrode the civic fabric of communities. Narrator's voice, a system at a crossroads as Daniel sat at his kitchen table, reviewing the board's refusal to release records. He wasn't just reading a piece of paper. He was staring at the intersection of law and power. Legally, he had rights. Ethically, the board had duties. But in reality, both were being ignored. His neighborhood had become a case study in a larger American dilemma. How much power should private governments hold over the people who live under them? And what happens when that power is abused? Closing beat of this section, the answer, as millions of Americans have discovered, is sobering. Laws provide rights, but without enforcement, those rights are fragile. Ethics demand fairness, but without accountability, duty collapses into domination. For Daniel, the fight ahead would test both the law and the moral compass of his community. And for the country, his story echoed a warning that unchecked power, whether in Washington or a neighborhood cul-de-sac, always leads to the same place: abuse. When the cameras cut from Daniel's drained lake and the angry boardroom meetings, the screen darkens slightly. A calm professional voice takes over, the voice of the experts. What follows is not heated testimony or neighborhood squabbles, but a sober, careful dissection of what this case truly means. 1. The legal foundations and their flaws. Professor Linda Harrington, Georgetown Law, HOA and Property Governance Specialist. The first thing to understand is that homeowner associations are not government entities. They operate as private corporations. That means they are not bound by the same constitutional checks and balances that protect individuals from government overreach. Instead, their authority stems from contracts, the covenants, conditions and restrictions, or CC and RS, that homeowners agree to, often by default, when they purchase property. She leans forward, hands folded. This contractual model creates a fundamental paradox. HOAs wield government-like power, the ability to fine, to lien, to foreclose, yet they lack the public accountability of actual government institutions. What Daniel's case demonstrates is how that power can be weaponized. The board demolished his bridge without following proper process, but his legal recourse was murky because the HOA could argue contractual authority. This blurred line is where many homeowners find themselves trapped. 2. Fiduciary duty and abuse of authority. Mark Delgado, HOA litigation attorney, Phoenix, Arizona. An HOA board is supposed to act like trustees. They manage community assets for the benefit of all members. But in practice, too many boards treat their role as a fiefdom. They forget fiduciary responsibility. They forget transparency. Instead, they pursue control, sometimes even personal enrichment. He shakes his head as footage rolls of the lake draining into muddy flats. In this case, the demolition of the bridge was retaliatory. It wasn't about safety or community well-being. It was about punishing a homeowner. And when Daniel retaliated legally by opening the dam, he exposed not just board overreach, but also deeper financial mismanagement. That's what happens when you push back. The rot beneath often comes into the light. 3. Ethical dimensions. Power without accountability. Dr. Elaine Foster, Professor of Ethics, Stanford University. From an ethical standpoint, this is a textbook case of unchecked authority. HOAs are micro-governments without constitutional limits. They can dictate not just property maintenance, but personal expression, the color of your house, the size of your garden, whether you can fly a flag. Ethically, the problem arises when boards stop serving as stewards and start serving as enforcers of conformity. She pauses as the screen cuts to archival HOA cases. A veteran fined for flying the American flag, a family penalized for building a wheelchair ramp. Daniel's board was not safeguarding the community. They were punishing him for independence, for building something that wasn't under their control. The demolition of his bridge was symbolic, a way of asserting dominance. Ethically, this is power without proportionality and power without empathy. That's when community becomes coercion. 4. Litigation trends and the real costs. Robert Chun, HOA defense and plaintiff attorney, Dallas, Texas. The real estate market in America has tied homeownership to HOA membership. Over 70 million people live under HOA governance. That creates endless litigation. In fact, HOAs are among the most common sources of civil lawsuits in states like Florida, Arizona, and Nevada. Numbers flash across the screen. 1 in 5 homeowners in an HOA will experience a legal or financial conflict with their board. Chun continues, what people don't understand is the financial asymmetry. Homeowners fund their own legal defense out of pocket. Boards use HOA funds, meaning they use your neighbor's dues to fight you in court. It's David versus Goliath, except Goliath is using your own money against you. The footage shows Daniel holding stacks of legal documents while, in contrast, the HOA's attorney bills are paid from a community account. When Daniel drained the lake, he flipped the equation. Suddenly, the board was on the defensive, facing scrutiny not just for retaliation but for financial impropriety. And that's rare. Most homeowners can't turn the tables. That's why this case is so significant. 5. Financial fraud and criminal liability. Angela Ruiz, certified fraud examiner, HOA auditor. The moment I hear about an HOA retaliating with destruction of property, I suspect something deeper. Often, boards that are aggressive are hiding financial misconduct. And sure enough, this case revealed embezzlement and tax fraud. Ruiz explains how HOA finances work. Every HOA collects dues, maintains reserve funds, and pays for community expenses. But unlike public budgets, there's little oversight. Audits are rare. State regulation is inconsistent. It's fertile ground for abuse. I've seen everything from treasurers writing checks to themselves, to boards remodeling friends' homes with community funds. She points to Daniel's HOA. The lake resort was their jewel, but it was also their cash cow. Events, rentals, tourism. Once the lake drained, the income stopped. That collapse forced financial transparency. And once forensic accountants looked, the fraud came spilling out. The ethical takeaway? Transparency only comes when pressure is applied. 6. Policy gaps. Why states struggle to rein in HOAs. Senator Thomas Kellerman, Colorado legislature, HOA reform advocate. Most state legislatures have tiptoed around HOA reform. Why? Lobbying. HOA management companies and law firms have powerful associations that fight against stricter oversight. They argue HOAs protect property values, but that phrase, protect property values, has become a shield for abuse. The senator gestures to a stack of pending bills. In Colorado, we've had constituents lose homes over $200 landscaping fines. We've had boards shut off water. We've had boards bankrupt associations through lawsuits. Yet passing reforms, mandatory audits, caps on fines, limits on foreclosure power has been an uphill battle. Cases like Daniel's provide the momentum we need because they show the absurd extremes HOAs can reach. 7. Ethical reflection. What community should mean Dr. Elaine Foster returns? At its heart, the HOA experiment was supposed to be about community, neighbors, pooling resources, sharing responsibility. But when power becomes punitive, community erodes. Instead of neighbors, you get enforcers and subjects. Instead of stewardship, you get control. Footage shows Daniel walking the drained lakebed, children playing in the mud flats where water once shimmered. Ethically, we should ask, what is the purpose of governance at the neighborhood level? To protect? To punish? Or to empower? Daniel's act of draining the lake was dramatic, even defiant. But it was also revelatory. It showed that when authority is abused, resistance is inevitable. 8. Expert closing lessons for the nation. The voices overlap in closing montage. Professor Harrington. We must treat HOAs not as private clubs, but as governing bodies requiring oversight. Attorney Delgado. Homeowners need stronger protections, clearer due process rights, limits on board retaliation. Auditor Ruiz. Mandatory transparency is essential. Annual audits should not be optional. Senator Kellerman. We can reform this. The law can catch up to the lived reality of homeowners. Dr. Foster. And we must never forget, communities are meant for people, not for power. The commentary ends with one final shot, the drained lake, a collapsed dock tilting in the mud, a reminder that unchecked authority eventually collapses under its own weight. The courtroom was quieter than anyone expected on the morning the ruling came down. No fireworks, no dramatic shouting, just the steady voice of a judge reading the verdict into the record. The board's conduct had been unlawful. The homeowner's rights had been trampled and corrective orders would follow. For Daniel and his neighbors, it was vindication not just of their claim, but of their dignity. After months of stonewalling, of being told they had no rights under the law of watching their own board twist, Florida statutes into a weapon against them, the residents finally had confirmation that they weren't crazy and they weren't powerless. The law, when properly applied, had sided with them. Yet, in that quiet moment of victory, another realization set in. The fight never should have been necessary in the first place. The symbolic victory Daniel's case was never just about a meeting date or a procedural technicality. It was about whether ordinary homeowners could be stripped of their voice by leaders who cloaked themselves in legalese and power. By proving that the statute had been misused, that the board's attorney had in effect fabricated a narrative to shield them, Daniel forced into the open what so many Americans feel about HOAs, that too often they operate as little kingdoms with little accountability. The ruling was more than a legal win. It was symbolic. It told every homeowner watching, from Florida to California, that the law is not a weapon meant only for those with the resources to hire it. It belongs to the people too. The broader pattern across the United States, millions live under HOA rule. In theory, these associations protect property values and foster community standards. In practice, as Daniel's battle revealed, they can become vehicles for abuse, secrecy, and overreach. One community sees its water shut off by a board seeking leverage. Another learns that thousands in reserves have disappeared under the treasurer's watch. Still, another faces liens and foreclosure threats over fines that spiral out of control. The names and details change, but the pattern remains: unchecked boards, obscure rules, and residents left voiceless. Daniel's case illuminated how easy it is for misinformation, or outright deception, to silence homeowners. A single claim about what the law really says was enough to strip dozens of people of their rights, until someone had the courage to challenge it. How many others never realized they could fight back? How many give up, believing the board must be right? The cost of silence, this is the hidden danger of HOA abuse. It's not just the financial cost of fines, legal fees, or property disputes. It's the psychological toll of living in a place where you're retold you have no say, where neighbors whisper instead of speak openly, where people move not because they want to, but because they're exhausted. Daniel's win mattered because it showed silence is not the only option, but it also underscored how fragile trust is once broken. A community where the board manipulates the law is not a community at all, it's a hierarchy. And hierarchies rarely feel like home. What this case teaches, the lessons are sharp. The law cuts both ways. Boards that misuse it can be challenged with it. Transparency matters. When records are hidden and meetings delayed, suspicion grows, and often for good reason. Courage counts. It only took one homeowner willing to read the statute for himself and demand clarity to unravel months of deception. Reform is urgent. Florida statutes, like those in many states, were written decades ago and often fail to account for the scale of HOA power today. Without reform, more communities will face the same turmoil. A warning and a hope for every Daniel who wins. There are countless others who don't or can't fight at all. Maybe they don't have the time. Maybe they don't have the money. Maybe they simply don't know they're being misled. That is the warning his case leaves behind. That justice in HOA. Disputes too often depends on persistence rather than principle. But there's hope too. The more these stories surface, the harder it becomes for boards to operate in secrecy. Each lawsuit, each investigative report, each whistleblower chips away at the myth that HOAs are untouchable. Awareness is power. As Daniel stood outside the courthouse that day, neighbors gathered around him. Some hugged, some cried, some just exhaled as if holding their breath for months. The board had tried to make them voiceless. Instead, they found their voice louder than ever. And that is the ultimate takeaway. HOAs exist to serve communities, not rule them. When that balance tips, homeowners have both the right and the responsibility to push back not only for themselves, but for the integrity of the place they call home. In the end, this case wasn't just about one Florida neighborhood. It was about what happens when ordinary citizens refuse to be silenced. It was about the courage to read the law for yourself, to question authority, and to insist that fairness isn't optional. Because in a country built on the idea of self-governance, no board, no matter how small, should be above accountability. In Florida, a single meeting turned into a showdown that exposed lies, abuse, and the fragility of trust inside America's HOAs. But from that struggle came a reminder we all need, that the law belongs to the people, not to those who twist it. And when ordinary homeowners rise, even the most powerful boards can fall. Because justice is not given, it is claimed.